So, good morning and welcome to this Inangar video podcast on the use of social media in a workplace. I have the honor to discuss with the topic with my two great colleagues that are Charlotte Knocker from Bella Law Firm based in Brussels and Carlos Pareja Frade from Augusta Abogados in Madrid. Let me say that the issue in a social network in the workplace is certainly a hot topic, also in the light of its growing popularity and daily use at all levels. So such platform for computer socialization have attracted the attention also of labor law because the use of social media also and even in the workplace represent a significant sort of litigation, as we will see later in this podcast. So let me say that the characteristic of the dimension for our purpose are essentially two. First fact is that what we say or what is reported on social media has much wider diffusion if you compare to a simple discussion between colleagues, for example. And second point, what we say or post remains in the web indefinitely in a sort of eternal present. So with this in mind, with my colleagues, Charlotte and Carlos, we want to deepen the experiences of our jurisdiction. So we have Belgium, Spain, and together with the Italian one, of course, and to verify if there are similarities or differences in the regulation of this phenomenon, both at legislative level and at the level of a national bargaining agreement. So let's move to see what we can define as the current legal trend in Belgium, Spain, and Italy. So I therefore give the floor to my colleague Charlotte for an initial analysis of the experience in Belgium.
Okay, thank you for the introduction, Michele. Well, both in Europe and in Belgium, the use of social media in the workplace, it's a broad topic, but it's also a legally fascinating one. Let's first look at Europe. At European level, two fundamental rights dominate the discussion. The right to privacy, this under Article 8 of the European Convention on Human Rights, and the freedom of expression, that's under Article 10. Both rights applied at work, but they are not absolute. The European Court of Human Rights requires a balance. This any restriction has to be based on law, pursue a legitimate aim, and be proportionate. An important notion is that the reasonable expectation of privacy. So if an employee puts content on the internet and it's accessible to the public, there is little expectation of privacy. Courts are clear. The more public the communication, the weaker the protection. So freedom of expression is also limited. Employees may criticize, but not in an abusive way that damages the employer's reputation. Now, let's zoom in on Belgium. First of all, Belgium doesn't have one single social media law. Instead, existing laws apply. So privacy rules, labor law, collective agreements, and case law. First is the Collective Labor Agreement number 81, which regulates how employers may control the use of electronic online communication. For example, email and internet use. So the rule of thumb is start with anonymous data. Only if there's a real reason, like protecting business interests or preventing wrongdoing, can the employer move to identify individuals. And even then, the monitoring has to stay proportionate and clearly communicated to the employees. Then the General Data Protection Regulation, or the GDPR, combined with the Belgian Data Protection Act of 2018, also play a part. These rules apply to all processing of personal data, like internet logs, emails, even LinkedIn or Facebook info. So the employer needs a legal ground, usually a legitimate interest. GDPR also requires transparency, data minimization, and security. And it gives the employees enforceable rights, like access to their data and the right to contest unlawful processing. Criminal law, the Belgian criminal law, adds another layer. unlawful interception of private communication is prohibited under the Belgian criminal law. Public posts, however, do not enjoy the same protection and may be accessed by employers. So, to be short, Belgian regulations on workplace social media exist, but they are spread across different laws and collective agreements.
Thank you, Charlotte. Sounds really interesting. And then I asked my colleague Carlos to what is the legal trend in Spain. So to you, Carlos.
Thank you, Michele. Thank you for your kind introduction. And thank you, Charlotte, for your very interesting opinion on this matter. So, in Spain, what we can say is this is obviously a hot topic, and it's becoming a bigger topic in the last years with expansion of social media. So, but we don't have in Spain any regulation, any general regulation about the use of social media at work. So it has been some CBAs, company CBAs or sector CBAs, who has tried to regulate the use of social media at work. Especially, they have tried to regulate some disciplinary measures that can be taken by the companies in case the employees do an incorrect use of the social media and publish some content that can be confidential or that can have negative consequences for the company. But as Charlotte was saying, there's always we must always do a balance here between fundamental rights, especially the fundamental right of freedom of speech and privacy rights, and also the right, the freedom of enterprise of the companies and the right of the companies to control the activity of their employees, especially during work time. So here, if there are no general regulation, or the CBA does not regulate anything regarding this topic, there are some internal policies that the companies can develop and can apply to the employees, just to, as Charlotte was saying, manage the expectations that the employees can have when using social media at work or related work with work matters. So I will be explaining some case law, which I think are very interesting in this case, just to facilitate the understanding of our of the people who is listening to this podcast.
Okay, thank you so much. So I think it's what you say and also what Charlotte said right before you. It's very similar to what is provided by the Italian legal system, because of course we can say that we don't have a specific legal provision that regulates the use of social network in a workplace, and nor there are special provision in actual NCBAs. So in collective agreement, we don't find any information on this topic. So it's something that is becoming more and more regulated by company as well. Despite that, what we can see from our perspective, it is something is moving, for example, from the point of view of the Italian privacy guarantor, because there is, let me say that the guarantor is starting to take a closer look to the cases and providing cases, papers on privacy protection. So this is, as probably Charlotte said before, something really important, because of course there is a high impact on privacy level, but as well there is an impact on, let me say, the employment relationship as well. So in the light of the above, we can underline two main rights at stake. One is provided by our Constitution, and it's Article 21 that provides for the freedom of expression of thought, also in the workplace, and that's a sort of first milestone. And then there is Article 8 of Law 300 of 1970 that provide for the prohibition of the inquiries into personal opinion or facts that are not relevant for the assessment of the employee professional attitude. So with this in mind, these are the two, let me say, milestone that we need to keep in mind from the Italian perspective and from our system. And so I thank you again, because I think we have similar experiences, and let me say, on the current legal trend. But what probably is nice to now underline is to, make a step more inside what can be called the current legal trend in the workplace, because this regulatory similarity is also reflected in the practice of operating in the workplace in the different members of the state of the European Union. And so I would therefore ask to Charlotte if she can help us to give us a framework by way of example of what can be, say, the current trend in a workplace. And more in detail, what can be done by an employer. And by saying that, I think about, for example, as we said before, the adoption of company policies, the possibility to adopt disciplinary procedures, or to do, for example, background checks. And on the other hand, what can be done by the employee. So as well, by saying that, I think about the good faith and loyalty, the correct use of the company assets, and so forth. So I leave to Charlotte the floor, just to, if she help us to enter more in detail in this current trend.
Well, as an employer, first of all, you hold a position of authority over your employees. This means you can give instructions and set expectations. And yes, that also includes rules around the use of social media. Now, these rules, they don't have to be limited to working hours only. If a post made during someone's private time affects your company's image or internal harmony, you're within your rights to address it. So the employment relationship is based on trust and mutual responsibility, and that that doesn't stop at 5 p.m. On top of that, you also have property rights. If you provide your employees with tools like laptops, smartphones, or access to your company's internet network, you have every right to set boundaries and how these tools are used, including what platforms can be accessed and for what purpose. So my recommendation for employers would be is, first of all, make your expectations crystal clear. Draft a social media policy that outlines acceptable behavior, potential consequences, and what constitutes misuse, both during and after working hours. That doesn't have to be restrictive, just clear, reasonable, and aligned with your company values. And also regularly updating and communicating this policy. This will protect both your business and your employees. Now let's flip the script and look at it from the employee's point of view. As an employee, you have a legal and ethical obligation to act with loyalty and good faith. This means carrying out your work duties responsibly, following instructions from your employer, and behaving in a way that doesn't damage the company's reputation, online or offline. It might seem harmless to share a funny story from the office or to vent about a stressful meeting, but once that content is online, it can spread fast and may be seen by clients, by colleagues, by competitors. So it's quite dangerous to do. And also as an employee, there's a confidentiality obligation, and that's a crucial one. According to Belgian law, no, specific to the Belgian law, employees must not disclose any trade secrets, business sensitive information, or other confidential details they come across during their employment. This obligation that continues even after the employment contract ends. So yes, that also applies to social media. Sharing confidential information on a public platform, even unintentionally, can be a serious breach of contract and could also be considered as a valid ground for immediate dismissal. So to conclude, my recommendation for the employees would be, before posting, ask yourself, could this harm the company? Could this harm a client? Could this harm a colleague? Am I sharing confidential information? If there's any doubt, it's better not to post it. So when in doubt, leave it out.
Yes, I think it's a good suggestion. Thank you, Charlotte. I think that you've touched on, let me say, many points that are in common with all Italian experience as well. So Did you find yourself in what has been said, Carlos? So with regard to the Spanish legal system?
Yes, thank you, Michele. So, regarding what Charlotte has said, I would like to underline the following. So, we always say to our clients that prevention is always better than taking action against an employee. So that's why the internal policies that Charlotte has been talking about maybe are the main tool that companies can have in Spain under Spanish regulations to face this issue, this challenge, I would say, and to manage the expectations that the employees can have, as Charlotte was also saying. So if you don't have any applicable CBA that regulate the use of social media at work, these internal policies can be the tool to avoid these situations where an employee can infringe this good faith, this obligation that he has within the company, and also to tell the employee that during working time, but not only during working time, but after the working time, there are some obligations with the company that they must comply with. So, especially focusing on this, the case law has resolved about some disciplinary measures that has been taken against employees who has done an non-correct use of social media during working time or after working time. And during working time, obviously, as the word it says, you must be working. So use of social media, an abusive use of social media can has a disciplinary consequence. And after working time, what you said in social media, depending on the consequences for the company, can be you maybe as an employee has to face these disciplinary measures that can be taken by the company. So there's always this balance, as I was saying at the beginning, between the freedom of speech, the privacy rights, and also the right of the company to control the activity of the employees, not only during working time but also after working time, if it can has a consequence for the company reputation or maybe for the company confidentiality rights of information.
Thank you, Carlos. So I agree with you because I think that the balance is really important of the two aspects that you said, and I let me say take the ball because it was interesting what you said about the case law because it's something that is let me say orienting our, for example, client company or the experience that we're facing, and so we can step into the analysis of this new aspect because it seems interesting for me to examine how in the various jurisdictions the case law has taken a position on the use of social media. As far as Italy is concerned, we had a famous, let me say, case law in 2015. It was a sort of extreme one, and it was provided for by our Italian Supreme Court in the case number 10955 of 2015. And the case stated that the court stated, sorry, the lawfulness of a dismissal and then the lawfulness of the conduct of a company that creates a fake Facebook profile of a woman to prove that an employee negligence. What happened in the present case? The employer created a fake female profile and engaged in a chat conversation with the employee during the working hours in order to prove that the employee was negligent and engage in personal activity during the working time. And of course, this to detriment of the company and the company productivities, of course. And in this case, the dismissal was considered grounded and lawful. So I'm curious right now, once you mentioned, what about Spain? Carlos, would you like to share with us some case law on the matter as you mentioned?
Thank you, Michele. So yes, I have chosen two case law in Spain, which I think are very interesting. The first one is one about a claim filed by a union who wants that a clause of a CBA must be declared null and void because it is a CBA which is applicable to employees who work on wildfire prevention and extinction. And the CBA says that these employees cannot provide personally information on social media about this wildfire prevention and extinctions. So it must be the companies who do this, or they must have the authorization from the company. The goal here is to avoid confusion for the people, for the population, and is to avoid that there it can be fake information or wrong information. So what they said, the union said, it was that this limitation was a non-valid restriction of freedom of speech of the employees, and the court, the national court, concluded that this limitation complies with the constitutional proportionality test, this balance that we were talking about, and did not violate any fundamental right. This freedom of speech limitation was right because there was also a goal here, an important goal here, which was the right of the ordinary people to have the right information and avoid this confusion on wildfire prevention. So this is one of the, I think, very interesting case law that we have in Spain, because it talks about the CBA, and also we have many cases about disciplinary measures that has been taken against employees who has posted on social media some opinions against the company on different ways. So I've chosen one that I think is very interesting, because here we have an employee who wrote a poem. He was very creative. He wrote a poem saying, to summarize, that the business plan of the company was kind of rubbish. So he did this he used this sarcastic way to criticize the company business plan. So he was dismissed. And what the ruling said is that this dismiss was null, because it violated the fundamental right of the employee of freedom of speech. He had the right to criticize the company. He did not. He did it in a original, creative way, but did not insult anybody. They did not say anything which was more than an opinion, did not provide any fake information, any fake fact. So what the ruling said is that the disciplinary measure taken, this dismissal, was not proportional, and the employee had the right to criticize this business plan of the company in the way he did. So it was, I think it is very interesting, because sometimes the legal limits of the freedom of speech must be taken into account when taking these disciplinary measures by the companies.
Thank you, Carlos. Really interesting, that point, especially the last one, of course. And Charlotte, what about the Belgian jurisprudence? Is there also a famous case law as well in Belgium?
Well, I don't know if it's famous, but let me share with you a court ruling that at least stands out when it comes to workplace internet use. The Brussels Labor Tribunal dealt with a case involving an employee who, over the course of just 16 and a half working days, he had spent more than 70 hours browsing stock market websites and updating personal files on his computer. To put that into perspective, that's almost half of his working time spent on non-work related internet use. So now the employee, he tried to defend himself by saying that the emails he sent and the personal files he created at work fell under his private sphere and were protected by his right to privacy. The court didn't buy that argument. The Labor Tribunal made it clear that while employees, they do have a right to privacy, that right isn't absolute, especially in a context of a professional setting. So employers also have a legitimate right to monitor work performance and make sure that company time and resources are used properly. In the end, the tribunal ruled that the employee's dismissal for urgent reason was completely justified. So what can we take away from this case? It is a powerful reminder that excessive personal use of internet at work, even if it feels harmless, it can have serious consequences. It highlights the importance of clear communication between employer and employee about what's acceptable and what's not.
Thank you, Charlotte. I totally agree with the last point because it seems to me also from what Carlos said that we must take into account that on one end, of course, we got the correct performance of the employment relationship, but on the other end, there is this protection of privacy of the employee in this
Yeah.
case. And we have a similar case during the summer that was on this point. There was a case law from the Milan Labor Court on July 2025. And the court recently stated that a statement against the employer made in a private WhatsApp chat by an employee cannot be used against him in a disciplinary procedure. The funny fact was the employee in question wrote in a chat some messages, but of course made a post on Facebook. And on the other end, say that a post on Facebook in an open group can be used in a suitability to reach an undifferentiated audience of the recipient. On that point, the court say that the Facebook post can be used and the private chat in WhatsApp cannot be used. So it is interesting. And so I think that we are operating in a context that is constantly evolving. And I faced this case and it was interesting. And so I don't know if also Carlos, but I think you mentioned right before is if it's the same for you. So this balance of interest that we have to keep in mind also from the Spanish point of view.
Yeah, that's right, Michele. So I'm going to answer you with the answer that the Spanish Supreme Court has provided on this case law. They have said that freedom of expression does not afford protection for insults, verbal abuse, or dishonorable accusations. And they have said that the seriousness and significance of the offense, as well as the intention behind it, must be taken into account. So, in this regard, the Spanish tribunals um, has always analyzed also the consequences of the behavior of the employee, of what the employee, not only what the employee has posted, but what has been the consequences of this posting. And in this regard, if this post has been done on a private or an open group, is an very important point that our tribunals has always analyzed to do this proportionality test that I was talking about and tell if in these cases, in this kind of cases, disciplinary dismissals are proportional or not. So yes, we have these similarities that must be considered always when taking these kind of measures.
Okay, thank you so much. I think all the above makes us understand the real importance of using good practices regarding the use of social media in the workplace. And of course, because our job, of course, as lawyers, we are called to give a opinion and support our clients on this aspect. So I think it's interesting to underline some brief legal advice that can be used. And so I ask you if we can give us some suggestion or tips to adopt in facing the use of social media in a workplace. And I will start with Charlotte and ask her. Probably she started at the very beginning of the podcast. She told us about a little bit, but I want to get deeper and to understand what are your suggestions on this topic.
Yeah, like as I mentioned earlier, having a clear IT policy is essential for any employer. It sets the ground rules for how technology and social media are used in the workplace, and helps to avoid confusion or security risks. So let me tell about a few key elements I strongly recommend including. First of all, be clear about what's allowed. For example, is a private use of company devices allowed, or is it completely forbidden? Is it allowed only during lunch breaks or in a limited way during working hours? also clearly outline what's not acceptable. Think about things like visiting certain websites, such as social media platforms, or forwarding sensitive information through unsecured channels. It's, in my opinion, it's also wise to ban opening attachment or links from unknown sources. And then we also have the bring your own device uh, policy. And on top of that, if employees are allowed to use their own devices at work, make sure there are strict rules in place. For example, company files should never be downloaded directly onto personal devices and should only be accessed via secured company system. Also, finally, it's a good idea to include clear guidelines about how the company will handle email access during an employee's absence, for example, due to illness or holidays, or after they leave the organization.
Thank you so much, Charlotte.
Yeah.
And so I jumped to Carlos and asked him if he has some suggestion or legal advice that you use within your firm in order to advise your client on this topic.
Of course, Michele, thank you. So, three main ideas that can summarize what we have been saying. So, for the companies, establish written rules, clear policies, which states what the employees can do or cannot do, always taking into account that the freedom of speech is involved in all these kind of policies. The second one, protect your confidential information or any content that could or protect yourself against any content that could harm your reputation or your company's image. Finally, third, prevention. As I was saying, it's better to prevent employees from doing unlawful conducts instead of taking disciplinary measures. So, in this regard, provide basic guidance, provide training to the employees to explain them what they can do or not when using the social media at work. So that would be the main suggestions that we do to our clients, and we think that are very useful to avoid some situations that nobody wants to face in this regard.
So I think what Carlos says is really interesting and impact as well what happened and what we suggested in from our perspective in the Italian jurisdiction, because as a firm we adopted a sort of decalogue for our client companies. In a nutshell, let me say is there are some advice that can be inserted in a possible policy regulating the use of social media on the workplace. And from the employee points of view, there are some points that we underline that can be summarized as follows. So to be aware of the policy, regulation, and codes that may discipline the use of social media within the company. And keep the neutrality in communication that may have an indirect or impact on a company image. Avoid to share information such as document, photos, and contracts that might be subject to confidential constraints. And on the other hand, of course, to separate a personal account from a corporate one, and of course, also sometimes also the personal devices. And with regard to the use of social media, the suggestion is to use social only during the pause, or of course, if it's strictly necessary, for a limited time, in case of in any case that's consistent with the task to be performed by the employee. So this, let me see the point of view from the employee part. And for companies, we of course encourage the development of the critical awareness in the use of social media. This by means of training and conscious practice to be shared within the employees. And of course, as well, the adoption of a precise policy on this aspect. I think my colleague and for all the example and all the, let me say that the work that's done on this topic and for the information that you have shared, because I believe that is a subject that has to be known more and more, and this even more for the implication that it can have on the context of employment relationship, as we saw in the case law discussed with you. But I think that it's a matter that we need also to monitor the evolution, given the growing use of related tools, also in performance of the work activities. I think about all the application that we use to do the calls, and so it's something that is really growing and expanding, and I think it needs to be monitored. And let me say that we can perhaps say that this is a challenge that is potentially at the very beginning, because I think that today with our discussion, we put the basis to face it more and more prepared, of course. So to conclude this video podcast, I would like to thank you again, Michael Lee, Charlotte Nockheyer, and Carlos Pareja Frade, and to say them hello and to the next meeting. And thank you so much for the participation.